So far, we have examined the substance of Hume's views. Is there reason for classifying his terminology offensive? There are two distinct reasons for concluding the opposite. His initial apprehensions about the distinction and, once offense has clearly occurred, his efforts to remove the perceived cause without changing the distinction itself. A third, more general factor should also be acknowledged, although it will not be pursued further here: Hume's frequently repeated ambition of being esteemed a friend to virtue. If this claim can be taken at face value, it reveals a most unexpected ambition in a man intending to offend his readers. It is also worth noting that Hutcheson, in the short introduction, allows that the notion of a moral law can be called artificial because it is not innate, but formed upon observation. And he also refers in the essay to moral distinctions which are the effect of art. To turn now to the first indicator of Hume's innocence, his obvious apprehensions about the terminology which introduces it. The apprehension is visible in the treatise itself, where, on first introducing the distinction, Hume stresses the difficulty of defining the word nature, than which there is none more ambiguous and equivocal. He immediately goes on to distinguish three senses of the term, arguing that in one of these senses virtue is not clearly natural, whereas in the other two senses it is. Shortly afterwards, at the end of the next section, he again stresses how the distinction is to be understood. When the naturalness of justice is denied, it is only in the third sense of natural, in which something is natural insofar as it is not a human construction. He reiterates the point because his desire to avoid giving offense, adding that though the rules of justice be artificial, they are not arbitrary. He then concludes with the following crucial remark: "Nor is the expression improper to call them laws of nature, if by natural we understand what is common to any species, or even if we confine it to mean what is inseparable from the species." Since, for Hume's predecessors, the law of nature is constituted by those necessary laws of human conduct, necessary because they are grounded firmly in human nature, this quotation provides a perfectly adequate non-voluntarist account of natural law, as in Grotius, for example. The cautious form of expression is most readily interpreted in terms of a desire not to be misunderstood. It does not appear to be hesitation over the use of the term, nor does this particular use indicate that the notion of natural law is being seriously thinned out. Further evidence that, from a very early stage, Hume entertained doubts about his terminology can be found in the letter to Francis Hutcheson, referred to previously. In that letter, one of his aims, apparently, is to overcome Hutcheson's misinterpretation of just the point at issue. "I have never called justice unnatural," he insists, "but only artificial." He then proceeds to a brief explanation and defense of his real position, beginning by quoting a line from one of the best moralists of antiquity, the poet and satirist Horace: "Atque ipsa utilitas justi propi mater et aequi." The passage can be roughly translated as, "Usefulness can be said to be the mother of justice and right," and may thus be thought to imply a skeptical principle, that justice is, after all, mere expediency. A closer examination of the relevant passage from the Satires suggests, however, that this is not Hume's intention. The passage shows that Horace's point is not skeptical. He aims rather to demonstrate that an awareness of the relevant facts of human existence is the key to a more sensitive moral and legal code than that implied by the Stoic paradox that all offenses are equal. He may even be understood to be providing an empirically minded protest against the plausible foolishness of a priori reasoning, a protest of characteristically Humean spirit. In fact, Horace can be taken as making two distinct points, both of which are Humean in flavor. The first is that the Stoic view is too crude because repugnant to common sense. Those whose creed is that all sins are much on par are at a loss when they come to face facts. Feelings and customs rebel, and so does expedience herself, the mother, we may say, of justice and right. This we can call the negative thesis. The second is a positive thesis in that it shows how social institutions develop in response to changes in human circumstances, or, in more familiar language, how moral and legal codes reflect human social evolution. In making the second point, Horace relies on the speculative account of social evolution and advances by Lucretius in De Rerum Natura. Horace's version is worth quoting at some length because it helps to bring out features that Hume wanted to emphasize in his own account of justice. It runs as follows. When living creatures crawled forth upon the primeval earth, dumb, shapeless beasts, they fought for their acorns and lairs with nails and fists, then with clubs, and so on step by step with the weapons need had later forged, until they found words and names wherewith to give meaning to their cries and feelings. Thenceforth they began to cease from war, to build towns, and to frame laws that none should thieve or rob or commit adultery. If you will but turn over the annals and records of the world, you may needs confess that justice was born of the fear of injustice. In other words, the primitive history of human life is a history of violence, until the increasing sophistication of human life led to the recognition that rules of justice were necessary in order to safeguard social advances, and to make further developments possible. Accounts of this sort are commonplace of the main natural law theories, as has been shown in earlier chapters. Most simply put, natural law theories account for the development of rules of property within a larger history of the development of societies, from primitive simplicity to more complex forms of social interdependence. Although Hume does not himself tell such a story in the treatise, he takes it for granted that there is some such story to tell. This is perhaps most clearly implied by his insistence that justice is a gradual development. The second inquiry, for example, gives the following instructive example. Suppose that several distinct societies maintain a kind of intercourse for mutual convenience and advantage. The boundaries of justice still grow larger, in proportion to the largeness of men's views, and the force of their mutual connections. History, experience, reason sufficiently instruct us in this natural progress of human sentiments, and in the gradual enlargement of our regards to justice, in proportion as we become acquainted with the extensive utility of that virtue. It is in this sense that Hume agrees with Horace's claims that utility is the mother of justice. Justice is the historical development, made necessary by changes in society. Its utility is shown most emphatically by the negative case, that without justice, society would simply collapse. Hume extends the point by building in the characteristic motivational point. The historical growth of justice shows the absence of a pre-rational impulse to be just, and we learn its value over time as its utility becomes evident. In this sense, utility is indeed the mother of justice, a sense which enables him to conclude in the letter to Hutcheson, with the observation that Grotius and Pufendorf, to be consistent, must say the same. They must say the same because their own accounts show the historicity of justice, and therefore also the crucial role played by utility. This is a provocative claim because Grotius explicitly resists Horace's view that usefulness or expediency is the mother of justice. However, part of the problem here is the very ambiguity of the word nature, of which Hume complains in his treatise. For Grotius, after stressing that justice is founded in nature, albeit remotely, being 3 degrees removed, nature may be considered the great-grandmother of municipal law, nevertheless concedes that there is no opposition between nature and expediency. Rather, the law of nature has the reinforcement of expediency, and so those who prescribe laws for others in so doing are accustomed to have or ought to have some advantage in view. So Grotius' opposition to utility is limited to the extent that utility is opposed to nature. For Horace, opposition of this kind is inevitable, and his reason for so thinking provides a clue to why Hume should have agreed. What he says is this: between right and wrong, nature can draw no such distinction as between things gainful and harmful, what is to be sought and what is to be shunned. Although a little unclear, the point of this remark seems to be that we are not directly led by nature to seek justice, but to seek what is clearly gainful and avoid what is harmful. Or, to put it another way, we have no natural motive, no original instinct to pursue justice. This is exactly Hume's point when, in the treatise, he argues that justice is artificial, and which, despite terminological changes, remains essential to the account of justice in both the essays and the second enquiry. The important conclusion to be drawn here is that, by describing justice as artificial, Hume is not propounding a new, more skeptical theory of this virtue. He grounds justice and sociability in just the way his natural law predecessors do, by insisting that it is dependent on utility. He does not deny sociability, but affirms it. This explanation accords well with Hume's own account of the matter in the Letter from a Gentleman. He there stresses the long and respectable pedigree of his opinions. Like Hutcheson, he concurs with all the ancient moralists in his moral theory. He adds that, in the treatise, the author, i.e. himself, seems sensible that he employed words that admit of an invidious construction, and therefore makes use of all the proper expedients, by definitions and explanations, to prevent it. The truth of this claim has already been illustrated. What reason remains, then, for doubting Hume's insistence that his is an inoffensive doctrine? He asks just this question in the letter, again speaking of himself in the third person. By the artificial virtues he means justice, loyalty, and such as require, along with the natural instinct, a certain reflection on the general interests of human society, and a combination with others. In the same sense, sucking is an action natural to man, and speech is artificial. But what is there in this doctrine that can be supposed in the least pernicious? In subsequent statements of his position, Hume took a more moderate course, in that, without altering the distinction, he sought to remove the offense by removing its source in the troublesome terminology. So, for example, in the essay of Original Contract, he makes the same distinction between two kinds of moral duties, but the offending terminology has disappeared. All moral duties may be divided into two kinds. The first are those to which men are impelled by a natural instinct or immediate propensity which operates in them, independent of all ideas of obligations and of all views either to public or private utility. The second kind of moral duties are such as are not supported by any original instinct of nature, but are performed entirely from a sense of obligation. When we consider the necessities of human society and the impossibility of supporting it, if these duties were neglected. Since our own primary instincts are too unruly to conform to the stringent requirements of justice, loyalty, and allegiance, these virtues must be of the second kind, founded on the established recognition of the general interests or necessities of society. This is precisely the reasoning underlying the treatise classification of justice, fidelity, etc. as artificial. But in this essay, justice and fidelity are described only as natural duties. The tactic of the second inquiry, published a year earlier than of the Original Contract, is similar, except that it does not so completely break with the language of the treatise. Justice is explicitly grounded entirely in utility, but, at least in the body of the work, the language of artificiality is absent. Hume's method is, in part, to replace a troublesome dictonymy with the emphatic mode. For example, public utility is the sole origin of justice, and reflections on the beneficial consequences of this virtue are the sole foundation of its merit. The artificiality of justice, although implied by this doctrine, makes only a timid appearance in the footnote to the appendix on justice. In the text to this footnote, justice is classed as natural because it arises necessarily, a point made in the treatise, but they're treated as of less importance than its foundation in rational artifice. In the second inquiry, the roles have been reversed. Firstly, we are told that justice arises necessarily in human life, and that, in so sagacious an animal, what necessarily arises from the exertion of his intellectual faculties may justly be esteemed natural. The footnote then adds a toned-down version of the distinctions made in the treatise. Natural may be opposed either to what is unusual, miraculous, or artificial. In the two former senses, justice and property are undoubtedly natural. But as they suppose reason, forethought, design, and a social union and confederacy among men, perhaps that epithet cannot strictly in the last sense be applied to them. But all these disputes are merely verbal. The final disclaimer here shows how far we have moved from the mood of the treatise. The author of the earlier work, despite some caveats in the text, could boldly ask, in one of his sections entitled Justice, whether a natural or artificial virtue. The important substantive question in 1740, however, has become, by 1751, a merely verbal dispute worthy only of a footnote. So it is clear that, in later attempts to restate his views on justice and fidelity, Hume sought, as far as possible, to avoid the troublesome terminology of the treatise, terminology which had caused both confusion and offense. In so doing, he acts very oddly for a man seeking to offend. The oddity disappears if we conclude the opposite, that, anxious to be esteemed a friend of virtue, he was upset to be thought one of its enemies. He therefore did his best to remove the unfortunate terminology responsible for the misunderstanding, and sought to emphasize the respectable character of his work. Thus he stresses in the second inquiry that, by basing justice entirely on utility, he is not introducing a new doctrine, but making more visible the foundations put in place, if not always clearly by the writers on the law of nature. These authors assign as the ultimate reason for every rule which they establish the convenience and necessities of mankind. Here we see very clearly one important reason why Hume could judge his theory of justice to be, in the main, the same with that hinted at and adopted by Grotius. To emphasize the point, he concludes the longish quotation from Grotius, which shows the historical and thus, in his terms, utility-dependent character of the explanation of property in De Jure Belli ac Pagis. There remains no good reason for believing Hume to have had skeptical or offensive intentions in describing the important virtues of justice, fidelity, and allegiance as artificial. Nevertheless, Grotius and his immediate successors saw no need for such a description. We need to understand why Hume did, so that question will be addressed in the next section. Before turning to that task, one final point should be made. It has been argued that, by dividing the virtues into the natural and artificial, Hume cannot be understood to be dividing the genuine from the purely imaginary or false virtues. He does not seek thereby to separate the real virtues from the mere pretenders. However, this does not mean that he is uninterested in making such a distinction. In fact, the reverse is true. He does seek to separate the genuine from the false virtues, but by quite different means. The test for the genuineness of a putative virtue lies not in its source, but in whether it is individually or socially beneficial. Qualities widely thought to be virtues, but which fail this test, are the mere pretenders. As the discussion of the monkish virtues in the second inquiry clearly shows. Precisely and wholly because these qualities fail the test of usefulness, and despite their widespread acceptance, Hume judges it appropriate to transfer them to the opposite column and place them in the catalogue of vices. In this operation, the natural-artificial distinction is not invoked, and for good reason. It is neither intended for nor capable of doing critical assessment of this sort. The monkish virtues are, on Hume's view, neither natural nor artificial virtues, and therefore are not virtues at all.